Hello everyone, this is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna PC. Um, I wanted to discuss an issue that comes up quite frequently in applications made by US citizens for their spouses and or parents who are visiting the United States having entered on a temporary visa such as a tourist visa or a visa waiver. Um, on our website immigration.com, we have a column called Cases from Our Files. I just posted a sample case. We have a whole list of cases. If you click here, um, this gives you the details about the case. Um, if you go back here and click on more, you see all the sample cases that we have posted based upon the categories. On the left hand side you see the categories. Okay, so going back to the visitor visa or the visa waiver entry case, what had happened was that the spouse of a US citizen entered the United States on a visa waiver. They then applied for adjustment of status to green card very shortly, I think just like 3 days after entering the United States. Their green card was denied based upon an allegation of fraud and or misrepresentation in entering the United States on a short-term visa with a preconceived intention of applying for a green card. So if your parent or your spouse enters United States on a tourist visa or a visa waiver or any kind of short-term visa, you can have issues that can be quite problematic because fraud, once it's alleged and service has made that finding. So if service has made that finding, then that particular individual against whom that finding has been made is permanently barred from entering the United States. There's a very narrow exception or waiver available, but that waiver itself requires extreme and exceptional type of hardship. So anyhow, so when we were retained, I looked at the case, I reviewed the case, I talked with these folks. In my view, this denial was unfair and illegal because it was quite obvious to me talking with our clients that they had acted innocently, not knowing what was going on and what they could or could not do under the law. Now, normally, ignorance of law is not an excuse, but it is an excuse when fraud is being alleged because fraud requires a guilty mind. It requires a scheming mind. Okay. So anyhow, we took over the case, filed a motion to reopen, and at the same time filed a new AOS application, adjustment of status application, with the waiver. Here's another tricky part. On the waiver form, there is a box that says, okay, I've committed the fraud and I want you to forgive me. But wait a minute, I have not committed the fraud. For me to say yes to that question or that admission is itself fraud or perjury. Because if I have not committed fraud and I admit that I have committed fraud under penalty of perjury, am I not lying under oath? So I refuse to let our clients check mark this box. I told them, I said, look, I think we have a tricky situation. I don't want you to sign, I don't want you to check mark this box. USCIS was firmly of the opinion that box has to be checked. And I thought we'll take it to court. We'll let a judge decide because this was such a bizarre issue that you want me to swear to perjury when I've committed you want me to commit perjury when I have committed no fraud, but by admitting perjury, I'm committing fraud in obtaining immigration benefits. Well, the good news is that USCIS did back off, and we did get the approval. Much to our relief, these folks are of course very concerned because the spouse who was the U.S. citizen had lived here for decades, and he's a very well-respected engineer. It's not somebody who has a history of any wrongdoing. So of course they were law-abiding people. It was very difficult for them to be in this situation. They had a very hard time for a few weeks while we got this thing straightened out. So the moral of the story is, when you have a situation where somebody is entering the United States on a temporary short-term visa and trying to convert to a long-term visa, accepting certain visas. I have here a comment that In some visa cases, there's a dual entry or a dual intent um, presumption, which allows you to apply for a green card even though you are here on a short-term visa, like H1s, L1s. You can do that. Even O1s. You can apply for a green card and not run afoul of the law. But be careful when you are doing this. It's always a good idea to check with a lawyer um, and see in your particular situation if filing for a green card or a longer term visa is a good option. Good talking with all of you folks. Thank you for listening. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.